Just to follow up on that, I'm taking all of that as given. Congress still hasn't defined the contours of what secondary liability should look like. Here we are debating them, right? So shouldn't that be a flag of caution for us in expanding it too broadly?
Well, I think that would be a cautionary tale to not go beyond the common law.
Well, a cautionary tale maybe to take account of where patent law is, that Sony relied on in part, for example. I mean, in Central Bank of Denver, as you well know, the court refused to imply any aiding and abetting liability under the Securities Exchange Act. And, so Sony sits in some tension with our law right there. And
well, but that was...
Isn't that a flag on the field for us?
Look, Central Bank of Denver, you already have like a made-up cause of action, and the question is, do we make up a bow on the made-up cause of action? I think that's different from what you have in a case like this.
So one made-up theory is okay, too bad?
No, I really do think here, given all of the text that you have and the court's precedents, which aren't nothing, that it's too late to sort of say this is all like an implied cause of action.
For sure, I accept that, but doesn't it suggest some caution here?
Look, it's always good to have caution,
okay,
but I would look not just to the patent law. I would look to the trademark law, and I would take the trouble. I would take the trouble to trace it back.
All right, but let me ask you this:
to the common law.
Even under your standard, that's not what the Fourth Circuit did, right? It didn't say, did you have specific knowledge of individual users who are infringing, and did you do something special with regard to them, such that you were substantially certain that you know that they would, in fact, infringe. We'd have to reverse under your standard, too.
I don't think so, but
today. That's not what they held.
Well, I think you and I just read this Fourth Circuit case differently. I read the Fourth Circuit opinion by Judge Rushing to specifically say the substantial certainty test is what's being applied and is what makes it.
They applied it in gross, and we've got an amicus brief from some intellectual property scholars that say that was wrong.
Well, you had a brief from some other intellectual property lawyers, professors who say that was exactly right.
But they did do it in gross, rather than say, I have knowledge of a specific student at the computer lab at Georgetown University. That's not what happened in this case.
No, but I actually think it is, but it's a little bit opaque in the opinion, because this case...
A little bit opaque.
No, but it's opaque for a very specific reason. Because, this case sort of piggybacks on the earlier BMG decision. And in the BMG decision, the Fourth Circuit says that once you have knowledge that the same customer or address...
No, not address, because it could be a lot of people at the address. The customer. And that analysis isn't what the Fourth Circuit did.
Well, I think the customer did it as to the bill payer, the account holder,
yes,
which of course is the same unit that Cox uses when there's non-payment.
I appreciate
when Cox doesn't get payment from grandma, they don't...
That isn't the common law, even under the restatement.
I think that is the common law still. I don't think you need...
I know somebody in this group of people was involved, and I did nothing. That's not substantial certainty.
So with residential customers, I think it is. But in all events, that was ruled on in summary judgment in this case. And then what the Fourth Circuit did, and I don't think you can read this part of the opinion differently, they said that Cox forfeited any argument that they didn't have knowledge to the specific customers.
All right.